People of the state of Michigan versus Larry Michael, M-I-C-H-E.
Mitchell.
No, it is Mitchell. We didn't, I knew that somebody told me that last time. Appearances, please.
Jake Carnes on behalf of the people.
Patrick Frigg on behalf of the defendant.
Thank you very much. The defendant's here seated at council's table. Also at the prosecutor's table is Mr. Sean Van Allen. He's the agent with the Michigan Department of Corrections to prepare today's pre-sentence investigation report. We are here today for a sentencing. The court has gone over that report. All right, doesn't look like I caught any corrections. Let's take a quick look here at. All right, I didn't catch any corrections. Mr. Carnes, how about you today, sir?
Yes, Your Honor. I would challenge the scoring of OV3. It's scored at 5 points for some amount of injury. Here we do have Deputy Kopanen noting in his report a hand mark around the victim's neck. We do have the victim's testimony at the preliminary examination that she was choked, her ability to breathe was impeded. And that's also supported in the police report, including what's included in the PSI. So I would say OV3 should be scored at 10 points because strangulation requires medical treatment. There's no evidence the victim sought any, but according to People v. Armstrong, that's not necessary. And I think 10 points would be more appropriate here. That does not change the guideline. Thank you.
She didn't get any medical treatment, but she had some kind of injury upon the neck.
Yes, Your Honor.
All right. Mr. Fragel?
It was not conclusive at the preliminary examination. This was a kind of a chase that went through shrubs and bushes, and there were various scratches, and it was our position that that scratch was a result of it was her travels and her rolling in grass. It was not a strangulation. That in and of itself doesn't require.
Hold on, do I? This does happen on occasion, and I'm reluctant about what to say, because then it looks like I'm telling the people what to do. So before I can make that ruling, I would need to have some piece of evidence. So this was a no contest plea?
That's correct, Your Honor.
Do I have the exhibit? People would have the exhibit.
Okay.
Or
Honor,
was it?
I
Oh,
didn't-
wait. Nope, it was not. I did not put an exhibit sticker on the prelim
You
transfer.
Did not, Your Honor. It looks like the police report was used.
Just give me the police
I'll give
report.
you the police report.
So we stipulate there was a mark on the neck, Your Honor.
Yeah, but I don't know, because you called it scratches, and I want to know, was it a scratch or was it like a choke mark? That's what I'm understanding the difference. If it's a scratch, then I would agree with Mr. Fragel. Thank you. So I'm going to put another exhibit sticker on there saying People's Exhibit number 1, which this court accepted back on November 17th of 2025. All right. Just a moment, please. All right. All right, the court is going to deny the request by the by the prosecution. It's already scored at 5 points where bodily injury occurred, didn't require medical treatment. And I understand that for 10 points, the scoring for bodily injury requiring medical treatment does not require the defendant to go and get that treatment. But what I don't have is any information that would have been required. For instance, on the strangulation, according to the report, again, whether we call it a strangulation or choke is semantics, but she didn't lose her ability to breathe. And she said she didn't feel like she was going to pass out. So were there injuries? Certainly. Were they of the level that would have required treatment? Well, she didn't get it. And I don't have any opinion here that says it, and I don't have enough in here to tell me whether or not medical treatment was required. Now, one moment, as I forgot to take a look at this. There's an attached EMT report here. 1 second. Mr. Carnes, you were going to say something?
No, Your Honor.
Oh, okay. All right. Now, there is another thing, and this is what I was trying to get to earlier. I don't care when a no contest plea is entered as to what the evidence is given, what evidence is given to the court to support the plea, as long as what's in it does support the offense to which the defendant is pleading guilty or no contest. What people often don't think about ahead of time isn't in their report. So while there's information in this report that shows that she suffered injuries, there's nothing to say that every treatment was required. Now, you'll note that when prosecutors do this all the time and defense attorneys don't object, and why would they? There are 2 lists. No, wait. 1, 2, 3, 4 pages of descriptions of photos, but there are no photos. If you all ever want me to take a look at something and really weigh it, if you all don't present to me photos and you only present to me this that lists that there might be 100 photos, I don't care if there's 100 or 5 or 200. Unless I see them, they mean absolutely nothing. So can't increase the scoring without more in there. That there's not enough inside this exhibit. So that's my reason for the ruling. Any other objections or requests for corrections?
Your Honor, on CFJ 284, page 11.
I am there.
There is no discussion of past use of opiates. However, the incident from November of either November of 22 or November of 2018.
It's 2018. It also appears in CFJ 284, page 6. I caught that too.
So I think there should be, and
that would also appear on it should have also be included on CFJ 145, page 1.
So there should be a history of heroin was the substance. I did check with Agent Banak, though, and he was able to confirm that for me.
All right, that needs to be added.
No objection.
Yeah. Thank you. I did catch that. Anything else?
No, Your Honor, if I may.
You may, of course. Thank you.
Thank you.
All right. Mr. Fragel, any objections, corrections, or amendments to make to the report?
No, Your Honor, we just wanted to add a letter of reference to the brief that was submitted.
Yeah, and I will note that this court received last week on March 5th, which was
Thursday morning.
Thursday morning. There we go. And I did get a copy of that, and I did read it. It was only 2.5 pages long with a couple statements attached to it, including something from a counselor.
I would forward that would be additional.
All right. One moment. Mr. Sorry. So again, I read that sentence brief from the defense. What was received, I think, on Thursday. I read it on Friday, and I've also read the updated letter that Mr. Fragel just provided to the court. Mr. Carnes, do we have any victim impact statement?
Your Honor, just what's included in the PSI is all of that.
Let me take a quick look here. Yeah, it was just the handwritten one that's attached to the victim's assistance impact statement.
Yes, Your Honor.
All right, thank you.
I would say there is an open question concerning the disposition at the conclusion of probation. So this is a,
In the probation, or you mean delay?
the delay, yes.
Yeah.
So it's my understanding, and there's some kind of a cloud of unknowing here as to whether or not we put it in writing, that it'd be reduced to a misdemeanor assault. So I think maybe between now and delay, we would want to pull the transcript unless the court has notes.
Let's take a look here in just a moment. I see a handwritten note that has your initial next to it that just says with a 1-year delay. This is on the written pretrial agreement that you all submitted to me. It does not reference any reduction. It just says a delay. Take a look here. There's nothing as to that. It just says he'd be placed upon a delay. But I'm going to tell you, let's just go ahead and wait. And I'll make a. We'll talk about that in just a moment. All right. Allocution. Did you have anything else to add?
Yes, Your
Go
Honor. The victim impact statement in the PSI does show that Ms. Grogan is still terrified. In certain situations, she has post-traumatic stress disorder from this. There was some kind of argument between the defendant and Ms. Grogan at the defendant's house. She went outside, she had to come back in to get her keys. And during this, both parties were intoxicated. But during this, the defendant choked the victim. There is a handprint or markings on her neck consistent with that. She did testify that her ability to breathe was impacted by that. And then the defendant dragged her through some thorny bushes in the backyard and then lied about it to police. And Deputy Kopanen did some good investigation work and was noting that the bushes were trampled down, and most tellingly, there was a bra in the backyard, which is consistent with the victim's statement to Deputy Kopanen and inconsistent with the defendant's statement to him. These are very serious crimes. I think the department's recommendation for 1-year jail on the misdemeanor is appropriate. I had discussed the 1-year delay of sentence with Ms. Carey. She threw that in at the final pretrial conference, and I don't have much information about it. I do know that we regularly have people plead, and then we wait and see how they do on a period of delay. Well, if the court goes along with the sentence, the defendant would only have a month, but I would also consider what he's been doing on bond, and it is some good stuff. I don't doubt that, but this behavior merits 1 year in jail, and I'd ask the court to impose that. Thank you.
Okay, Mr. Fragel, your position, sir?
Your Honor,
Your allocution.
Yes. Well, the prosecuting attorney and I, through the defendant, agreed to a 1-year delay of sentence. That's the recommendation.
On count 3.
On count,
which is listed as count 2.
Added count 3, yes, the attempted strangulation. With the purpose of that, the intent of that is to delay the sentence because he had been engaged in the men's group and sobriety, and he's got 2 jobs. So to assess a year, 12 months for the misdemeanor aggravated domestic violence, which arose from the same set of facts, would be kind of defeat the spirit of the delay of sentence. I understand, and so does my client. I think his performance shows that he understands this is a very serious incident. We're not going to delve in and try to put ourselves into what happened that night, because there are 2 sides to both stories. But He did wrong and he accepted his responsibility. Now, he sat in jail for 23 days already, which I think is a function of jail, is to get him sober and see if he can begin his rehabilitative process. That was back beginning in, I think, October 1st or so is when he was released. So we have October, November, December, January, February, half of March, without any violations, nothing but good conduct. And that's Mr. Mitchell. You see, when he was in high school, even he dropped out of high school in the 10th grade. But as soon as he sobered up and got around to it, he got his mechanic, I think a mechanic certification at a local agency here, and became, gainfully employed. But then again, he started engaging in drugs and alcohol and found himself in trouble. So I think it's important here is he's realizing this is his last chance. He's on the verge of prison. He's going to let down his significant other who is here today, as well as his parents. They have been supporting him. This is not all just Larry. This is his family who really got together and have helped him on this. So the point of the delay of sentence is to keep him under the microscope, see if he can find a long-term path of sobriety and free of crime and free of other violations. And how do we decide that? We look at how he performed on bond. I think he got an A+ on bond. I believe the prosecuting attorney would agree with that, or at least an A from the prosecutor. And it's not just AA meetings and the men's group. He's at his employer. Both of his employers, both of his supervisors have given him high marks. He's trustworthy, he shows up on time, and he gets the job done. Those are the signs of a sober person who is being productive and industrious in his life. And perhaps most important, we haven't heard of any bond violations having contact with the victim in this case. The victim and he go back several years. I'm guessing 6 or 7 year relationship. But as of that night, it's been broken off and he has had no contact and no attempts to contact her during that period. So the purpose of the delay is to keep him on his path of rehabilitation. We would ask the court to grant that delay and to hold any jail on the misdemeanor in abeyance. So, violation, he's going to serve it for both, but otherwise hold both in abeyance. Thank you.
All right. Mr. Mitchell, you have the right to make a statement if you choose. I know there was a no contest plea, so I understand if you don't, but if you choose to do so, you may.
Yes, Your Honor. I just want to continue on with what Mr. Tragel said. I'm trying my best to turn my life around. I understand what I did was a grave mistake that I wish I could take back. I had a job, a full-time job before I went to jail, and I lost it, went to jail. And within that time, I had a lot of time to reflect on what I did and the wrongs I've done. And I think going back to jail is just going to put me backwards again. And I would ask that you would just give me the chance to show that I will continue on the path that I'm on with sobriety, being a productive member of society, and continuing on with trying to live my best life at the time. And that's pretty much it.
All right. Thank you. All right. So as I will say often, it's not until the court gets to this phase that it gets to actually apply any discretion. Typically, when I make or accept a plea, I take the plea, the elements for the offense to which the parties have reached an agreement, and I take the facts, whether they're admitted by the defendant or admitted, such in this case, through an exhibit. Do those facts meet that offense to which the parties have agreed the defendant would plead? That was done. Now it's my turn. The defendant was on probation. So when I look at his performance on bond this time, yes, he's been compliant because now this time prison is hanging over his head. But before, When this case, this offense was committed, it was while on probation for the district court. In that case, he was on probation for assaultive behavior. Started out as an aggravated assault. The defendant pled no contest to an assault and battery, and that plea was on May 19th of 2025. He was given 12 months of probation, and he made it 4 months. That's why he's got to be performing on bond. Now, I also looked at the defendant's description of the offense. Quote, she was trying to kick my door in and coming at me in a threatening way. That is self-defense. So when it comes time to him making a statement, his choice was to say, I have a self-defense claim. All right. Makes me wonder why somebody entered a plea if they thought they had a self-defense claim. Well, again, we know that the defendant has had issues with alcohol and marijuana for nearly 20 years. I had an issue with methamphetamine for a while, but that seems to have gone away. Had an incident with heroin or an opiate back in 2018, but a lifestyle of booze and weed sure as heck is not helping the defendant. Let's also take a look here at the factors, the facts of this case. The two had been in a dating relationship for about 6 years. They were separated for about a year, but then began to resume their relationship for about 2 weeks leading up to this incident. And the defendant and victim have both been drinking liquor and a couple 24-ounce beverages. And at some time, the defendant started calling her a fictional whore. And then from there, it escalated. He grabbed her by the neck, pushed her back to the ground, squeezed her neck, causing her to be unable to breathe for about 5 seconds, covered her mouth with his hands. After he stopped choking her, he began to drag her outside by her hair and her neck out into the front yard, where he then continued to insult her. Her to leave. The victim re-entered the residence to go get her keys for her vehicle. After re-entering to get the keys so she could leave, the defendant chased her from the interior of the home back out into the yard. Then, as she was trying to get away, he caught up to her, tore off her shirt and bra, pushed her to the ground. Then he dragged her through the backyard, which was covered with thorny plants, and the thorns caused various cuts on the victim. She began screaming for help, hoping other neighbors would hear her. Defendant lied because he said that he had been completely sober and that she was the one that was drunk. He also said that she forced her way into the house, but later on admitted that no, he actually went and picked her up from work. And of course, a preliminary breath, while a relatively low breath test by the time that they got around to conducting one, the next morning at 11:45 a.m., which was almost 8 hours after, he still had a 0.034. So again, that level's not high, but that's 8 hours later. So when I look at the defendant's prior criminal history, it started out as a juvenile with a retail fraud. Then actually had two cases pending at the same time. Another one was for possession of marijuana. Made it about 6 years after those cases where he picked up another marijuana charge in 2012. He had a 6-year gap between that when he picked up the case that we talked about, which was the heroin or the opiate. And I'll note here, Mr. Van Atwell, do you know why count 2 of 7 on CFJ 284, page 6, carried on to page 7? Why it was charged in November 25th, 2018, and he was given bond, and yet the plea wasn't entered until 4 years later?
I do not answer that, Your Honor.
You know, I'm going to say that there's enough evidence to believe by preponderance that he absconded. And I can tell you why, because, now hold on, if we look at, before anybody says anything, if you look at entry 3 of 7, which occurred on the October 14th of 2021, he was on bond when that offense occurred. And the only offense for which he could have been on bond for was the one I just said was 2 out of 7, which means he had to have been on bond and had to have been in some kind of absconder status. I cannot imagine how a district court would place somebody into a rehab program for 4 years. So he must have been in an absconder status. Well, in that file in 2021, he was sentenced on November 17th, and he was already violating his probation in less than 2 weeks. So then he got another one and violated less than a year later, about 11 months later, and he was terminated unsuccessful. Oh, we had another, that was also for a charge of retail fraud, then followed up by another retail fraud because he was on probation for retail fraud and he went out and stole again. Well, he picked up a charge here in 2024, but that was dismissed. That was the operating without insurance case, so, but it's dismissed, so I ignore that. Then we get entry 6 of 7. This is the one from 2024, where the arrest date was in March of 2025. He was sentenced, and I've already talked about this, on May 19th for an assault, and he violated probation within 4 months for more assaultive conduct. That's what led to this case today. We have a defendant who violates bond, violates probation, has the same kind of conduct as he tends to repeat the retail frauds, and now we've got a continuation of assaultive behavior. So I have no idea what led anybody to believe, to think that I would give a delay sentence. So I will give my sentence, and then the defendant will have the right to withdraw the plea pursuant to the Killebrew agreement, which, by the way, you all went through the plea, and I vaguely remember this, thinking, well, what does he get if he does the delay? Nobody put it on the record, so I don't know what Miss Carrier was thinking, but we didn't, probably just trying to resolve busy cases that day, but we didn't get it very well documented, but it doesn't matter, because I read the police report that day to take this all into consideration. And while I said earlier, I don't get to apply my discretion until sentencing, somebody should come and ask a judge, are you likely to give a delay? Here's his report, here's his old PSI. But that didn't happen. I already knew back then I wasn't going to likely grant the delay. Now that I've seen it, no. Domestic violence. And then he comes here and tells me in the answer here, where he didn't need to make a statement, his statement was self-defense. That should offend everybody. So, sentence of the court here is the court for count 1. This is the domestic violence. We're going to do this. We've got a $50 state minimum fee for the misdemeanor, a $68 state minimum fee for the felony, a $130 crime victims' right fund fee, a $300 court cost for the processing of this case, The court adds a $500 fine. Mr. Fragel is retained, so there's no attorney fee. Did we have to do a DNA fee here, Mr. Carnes?
Yes, Your Honor, to the Wexford County Sheriff's Office.
$60 DNA fee paid to the Wexford County Sheriff Department. Now, the court is going to,
Your Honor, there's restitution.
oh, restitution of how much was that again?
$332.13.
$332.13 in restitution, and that's payable to, what was the name again?
Carly Grogan.
Carly Grogan. So as to count one, well, the law says that for misdemeanors, we must start, or we, meaning courts start with the presumption of just fines and costs. However, that doesn't apply when there is an act of domestic violence or assault, battery, conduct kind of stuff. So the court does not need to establish any kind of reasonable grounds. However, to the extent that can apply, the defendant has had prior assaultive behavior, was on probation for that, and he only made it 4 months into the year of probation. Therefore, there definitely is evidence to support reasonable grounds. The court, as to count one, sentences the defendant to 2, and I know the maximum punishment is up to a year. Court sentences the defendant there for that offense to 180 days with 23 days of credit. And now we come down to the assault with intent to cause great bodily harm or by strangulation, which was an attempt. Here, the sentencing guidelines are 10 to 23 months. Again, he was on probation. He's violated probation not only in the last file, but also other files. And he's violated bond. And he's got a line of dishonesty, criminal convictions. He's had a life now where he's been of marijuana or alcohol for 19 years. The court takes a look at this sentence, and quite honestly, the question for me today is, do I send him to prison? Court is going to choose not to. I will place him on a period of probation. That period of probation will not be 20, let's see, will be for a period of 36 months. I adopt the terms or conditions of probation that are contained in the PSI in pages CFJ 145, pages 2 and 3. I find that those terms or conditions, those involving anger management, drug testing, drug outpatient residential treatment, not to use or possess alcoholic beverages and other intoxicants, those are all appropriate, because while the defendant apparently only used heroin once and stopped using methamphetamine, he definitely has not stopped using alcohol and marijuana, and those appear to be contributing to his violent behavior. Therefore, again, I find all those terms and conditions are well suited. Plus, he's not to use any object as a weapon, and of course, he can't possess any firearms anymore because of the domestic violence offense. So here, the court sentences the defendant to within the sentencing guidelines, and I will sentence him to 330 days. That's basically 11 months with 23 days of credit. He'll of course have the right to be released from probation at halftime if he's successful with the terms or conditions. All fines and costs are required by law to be paid within 56 days, or a 20% penalty will be added. However, if he's continuing to make payments during his probationary period, the court will waive any interest. The court also must therefore add the supervision fees of $30 a month or $60 a month if there's any electronic monitoring. Now that I've issued my sentence and have applied my discretion to the sentence, in this case, I understand that the defendant had a Killebrew agreement and has the right, I think, to withdraw. No, not that I think. I know he has a right to withdraw his plea if he so chooses. Mr. Fragel, do you need some time to go speak with your client?
I think just a minute or so.
That's perfectly fine. I'm just, hold on, yes,
I
sir?
don't believe the halftime probation
Doesn't,
applicable, and you did say it did apply, so I just want him to have all the information.
it doesn't apply Is it because, because it's a
Active.
violent,
It's
it's an act of violence, so you're right, it doesn't have the right to, yeah. Sorry, I was mostly thinking about the delay. We'll take a brief recess. Mr. Mitchell, you're ordered by the court, you are not to leave the court, this floor of the courthouse.
Was it?
Thank you. We're in recess. Does the defense choose to withdraw his plea?
No, he plans to go forward with the sentence that was been imposed by the judge with one question, Your Honor.
Certainly.
He is accepting the sentence. We just have a question whether or not he would qualify for work release.
Well, all right, my reason for pause is that we do not have a set work release program through the Wexford County Jail. The court can consider there is a way in which I can do work release. I'll explain it. Mr. Carnes, do you have a position in response to the request for work release?
I'll leave it completely within the discretion of the court, Your Honor.
Thank you. Mr. Frankel, what days of the week does the defendant typically work?
Monday through Friday.
I will,
3:45 p.m. to 3 a.m. That's it.
okay, so here's what often happens. We don't have a work release that generally does that allows it that way. The court can allow a defendant to serve his time on weekends. And here's one reason why people don't like it. Because when there's obviously processing, searching every time the person comes and goes. But because the policies at the jail work in the way they do, they don't get put into a general population. They'll generally come back in and they have to be put into isolation or the initial drunk tank in effect. And by the time they are done with the time of that, it can be put back in general population. Then they're released again. So I'm going to tell you, it's not uncommon for me to get somebody coming and say, yeah, I don't want to keep doing this. Now, I'm not telling anybody what to do, but I can create a way that allows the defendant to do that. Now, one moment here. Mr. Van Atmel, any input from you today on this point? It's really not managed by your office, really. It would be through our community corrections office. And it ends up being a huge pain. But
Yeah, I just, if he's out in the community, you would also have to be reporting to probation.
yeah,
So he would have to, his work would have to accommodate that as well.
He does have a valid driver's license, Your Honor. It's-
that's not so much the issue here. All right, so here's what I'm going to do. Unless somebody objects. Court is going to have the defendant begin his sentence today. And the court will meet today. I have nothing on my docket tomorrow or Wednesday. Fravel, please don't let me forget this, but call me back tomorrow and I will call the right offices to make sure you can do this, okay? When I say to make sure we can do this, it's because in the back of my head, I'm also remembering we had some issues with this. I want to find out what that was. If there's an issue, then you and I will speak. But if I'm able to make the arrangements, I will do so. Okay, and what we generally do is we put the person on a. Well, let's see, does this work on Fridays going to Saturday morning? Is that right?
Yeah, it's from 3:45 p.m. on a Friday to 3 a.m. Fridays may go away though, it's just overtime right now.
So your Friday time shift is an overtime set?
Yes, it's scheduled out right now that we work every Friday, but that may go away.
Do you work every Monday too?
Yes,
And what about Sundays?
Sundays, no.
All right,
Sunday.
No, it's Monday afternoon, 3:45 to 3 AM, to Friday afternoon, 3:45 to into Sunday or Saturday morning at 3 AM.
the court is going to, at least as now, pay attention to the way I'm phrasing it. I'm phrasing it for a reason. The court initially will deny the request. However, Mr. Fragel, do as I already suggested. Make sure you stay in contact with me tomorrow. Please do it via email and copy Mr. Carnes. And then I will track down the possibility of the work release. Okay. And just email me or email the court clerk. Okay. If you probably have my email. Seems like you.
I don't know.
No?
No.
All right, it's called Cool Judge. No, I'm just kidding. If you go down to my clerk's office, they'll give you my direct email, okay?
Okay.
And then email me and email Mr. Carnes and we'll see what we can do. All right, but it's not a work release. And that's the challenge. That's another thing is because you actually would get released and you wouldn't return to the jail until, like, I'd probably tell you to return Thursday. You'd skip Friday. You wouldn't work Friday, Saturday, or Sunday, and then you get released on Monday morning, in effect. Then you're serving your sentence at 4-day increments. So you realize you're going to be serving over the next 2 years. Every week for 2 years you're doing this. That ends up being difficult. 60. Yeah.
Hopefully you have some good time.
Yeah, that's so. Well, anyways, that's the way I'm going to rule today. I'm willing to adjust my sentence to allow work release after I find out if we're able to still do it. And all right.
Thank you.
Yep, hold on. We need to do advice of rights. Mr. Fragel's going to bring to you, sir, 2 copies of one document. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of your copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. And that is typically done by filing a claim of right to appeal. But however, based upon the plea, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the copy that you're taking with you and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Again, fines and costs, I'm not going to assess that, or I'll waive that 20% penalty as long as they're paid by the end of the period of probation. Also, the 2 sentences obviously run concurrent with one another. Thank you. We're adjourned. I'll hear from you tomorrow, Mr. Thank you.